going to be completely honest. I hadn't brushed my teeth.
I take a holistic view of the data and try to find anomalies.
I'd say the Commonwealth of Massachusetts. This court is now open. You may be seated.
In week 2 of the Karen Reed trial, questions about the science and the data.
I don't really understand all that. It's very difficult to understand.
Is the data dumb? The second week of the Karen Reed trial featured people like Carrie Roberts, the Cellebrite forensic expert Ian Whiffin, and also Jennifer McCabe. I'm attorney Andrew Myers, and joining me for this episode is California attorney Yoli Medina. Yoli, thank you for joining me.
Hi, thanks for having me. It's been a while.
Yeah, it has, and I kind of miss you, and I'm sorry that we haven't had you on more. I know you're busy out there, and you were with us quite a bit during the first trial. It's hard to believe that was a whole year ago.
Yeah, God,
you know,
a long time.
The second trial, the second week featured Ian Whiffin from Cellebrite, Carrie Roberts, and the week closed out with Jennifer McCabe on the stand for a third day. And, you know, I don't know. See, I don't have a sense for how the second trial is going. It's very different. The presentation is different. Of course, Special Prosecutor Hank Brennan is the prosecutor as opposed to Adam Lally. Do you have a sense that things are going differently and better for one side or the other at this point?
I don't. It's hard to tell. Both the prosecution and the defense are really going hard at cross-examination. And I don't know if it might be a little too much, but I don't have a sense exactly. But I do know that Jennifer McCabe is doing a better job this time around than she did the first time.
Yeah, I forgot to mention to people that Lainey Law is on vacation this week. And so Yoli was nice enough to join me and help me with this episode. Yeah, we're going to get to Jennifer McCabe in a minute, but the first witness I want to talk about who was actually on the stand before her is this Ian Whiffin. Remember him from last year?
Yeah.
He's the forensics examiner for Cellebrite. Cellebrite, of course, being the one of the top, if not the top, telephone extraction data companies. So he was on the stand, and on direct examination, he told the jury that reliable software was used to show the how long to die in the cold query. And he says the software says it happened at 6:23 a.m. and not 2:27.
Data sources used here. com.apple mobile safari.plist is known to be a reliable location to get search timestamps from. We know that it's good to show the time that a search was conducted and what search was conducted. It doesn't record if the device is in private browsing mode. The only time it shows how long to die in the KICD is at 6:23:51, and the only time it shows how long to die in the cold is at 6:24:18. There's no other mentions of either of these searches anywhere else in this file.
One question I had is if it shows in the tabs at 2:27, but it really happened at 6:23, how many convictions are based on a wrong interpretation of this scientific data?
Well, yeah, because it's a software, and I don't know what's all involved in the software, but how do you know that the software is accurate?
Exactly. On direct examination, Whiffin testified under questioning by Hank Brennan that although there were pings in various locations, he was certain that John O'Keefe's cell phone was outside 34 Fairview the entire night and into the early morning of January 29th of 2022.
Is that inconsistent with a phone being in the same place, not moving that entire night?
It could indicate movement. It could indicate refinement.
Is it impossible to tell?
It's impossible to tell at this level of detail anyway.
Are all of these dots, given the range, 10 meters or under, are all these dots and all these readings of the high frequency data that you compiled for that night, are they all consistent with Mr. O'Keefe's phone being near the flagpole and not moving that night?
Objection, Your Honor.
I think that's a reasonable assumption.
Okay, so it's an assumption. It's not, I guess the science isn't as exact as we'd all like to believe, but he said it's an
It's a
assumption.
reasonable assumption. Well, what's another reasonable assumption? That's what I'd want to know.
That's a good question. I hadn't picked up on that. It's an assumption. It's a reasonable assumption, which it's kind of like a Chinese menu. You know, you can get column A, column B, or column C. That's a good point. I hadn't thought of that. Okay, so that was the direct testimony, but on cross-examination by defense attorney Robert Alessi, Whiffin acknowledged reduced accuracy of the location data and acknowledged that O'Keefe's phone could have been in the house.
This, in fact, was a depiction you included in your report on page 29, correct?
Correct.
Interesting and notable. You did not include that depiction in your timeline that you discussed with the jury yesterday, did you?
I did not know.
But it was important enough for you to put that depiction in your report, correct?
Correct.
And notably, the larger white circle covers a substantial amount of the house at 34 Fairview, correct?
Correct.
So, given your testimony on direct yesterday with Attorney Brennan, the phone of John O'Keefe, according to this depiction, could be anywhere within the largest white circle, correct?
Correct.
That's kind of shocking. Maybe I shouldn't be shocked, but the way the direct testimony went in was, yeah, the science and the data shows, fairly clearly that the cell phone and therefore Mr. O'Keefe, by deduction, I guess, were out on the front lawn all night. But if you look at the data and start, looking under the hood, so to speak, there was that whole big white area that he could have been in based on the margin of error for the location data. That, to me, is reasonable doubt. I don't know about you.
Well, yeah, and I question how they came to this. Like, how do they, and maybe I just don't understand it, but it does create reasonable doubt because it looks like he could have been closer to the house, like almost near inside the house.
Yeah, and we're going to get to something that's even more disturbing in a minute. But, one of the questions that one of our commenters had was that, these experts come on and they're supposed to have, more knowledge, expertise, and experience than we do. And they're supposed to be able to educate us. It's beyond the knowledge of the average person. But are they, bedazzling us with brilliance, or are they baffling us with what? So Alessi also showed the jury a portion of Whiffin's own report showing the GPS coordinate and accuracy radius we just saw, and it jumps around during the time in question.
Over the next few hours, the GPS coordinate and associated accuracy radius jumps around numerous times between the house and the road. Did I read that correctly?
Correct.
And therefore, over the next few hours, according to your report, the phone of John O'Keefe could be in the house, correct?
Based on the low accuracy information, yes. Correct.
That's big. That is big. That is
That's
big right there.
reasonable doubt. Yeah,
I'm sorry?
that's a reasonable doubt.
Absolutely. And it's their own expert. It's the Commonwealth's own expert. One of the problems for the Commonwealth's case is that hidden in the data is that O'Keefe's phone showed steps being taken after the time prosecutors claim O'Keefe was struck.
Do you recall writing in your March 2025 report the following? The final health activity of note on John's phone can be seen to have occurred between 12:31:56 and 12:32:16, during which 36 steps were recorded, covering a distance of 25.4 meters, again that 84 feet, according to healthdbsecure.db. Do you recall writing that?
I do.
And you used in your report 36 steps were recorded covering a distance of 25.4 meters or 84 feet, correct?
Correct.
And you know what's shocking about that is that John O'Keefe's phone could have moved 84 feet in those 36 steps, and it's only 72 feet from the flagpole to the front door.
Yeah.
That to me shoots this whole statement by this expert down the tubes.
Yeah. So, which is, yeah, in essence, this expert is focusing when he was being questioned on direct, he was focusing on the parts that help the prosecution, but there's other parts that help the defense. So in this type of case, it's sort of like, how do you even make sense of this technology? Like, does it help? Does it hurt? It just causes reasonable doubt.
Yeah, for their own expert. I mean, there's always a margin for error, I guess. I mean, I used to play darts and I rarely hit the center thing. There's a margin of error. But I mean, for your own expert who you're putting on the stand because you have the burden of proof, as you pointed out, beyond all reasonable doubt, for him to acknowledge such a gaping hole in the, shall we say, je ne sais quoi of this expert report, it's astonishing. I just find it really astonishing that he was even put on the stand. I mean, there are other companies, I think, and in fact, there are. We're going to get to that in a minute. So I think the Commonwealth's in trouble. I think the Commonwealth is in deep trouble based on that. Then the other thing that Ian Whiffin tried to do is that he claimed that the cell phone battery temperature showed O'Keefe had to have been outside all night. If you think that last clip was bad, but he did an experiment by putting the phone in a freezer where the battery temperature dropped 50 degrees in 15 minutes. But the data showed O'Keefe's phone that night dropped only 11 degrees in 15 minutes, which I deduce he's, the defense team is trying to tell us, well, so Mr. O'Keefe was someplace that was warmer than a freezer. But anyhow, that led to what must have been some rather embarrassing admissions by Mr. Whiffin.
What is freezing in Fahrenheit?
Don't know, but it's 0 degrees Celsius,
Right.
and it was -5 degrees Celsius at the time.
Right, but would you agree that, and I want to be fair to you because I know you use Celsius more
Yes.
than Americans who use Fahrenheit, but would you agree that 2 degrees Fahrenheit is the freezing point in Fahrenheit?
I honestly wouldn't know.
Okay. Do you know what the temperature was in Canton in January 29th, 2022?
I do not know.
Don't you think that that would be an important piece of information in analyzing where the phone of John O'Keefe was on the morning of January 29th?
I didn't think it was.
To me, that's shocking. Two things come to mind. He's trying to say that you can tell from the battery temperature, you can tell, where Mr. O'Keefe was. Shouldn't you have done your research when you're putting putting iPhones in the freezer? Shouldn't you have done your research and known, Fahrenheit and Celsius. I remember as a little boy in elementary school, they taught us Fahrenheit and Celsius, and I knew that 0 Celsius equaled 32 Fahrenheit.
Yeah.
I mean, that's
Yeah.
just shocking.
I remember thinking that, well, Celsius is easier because it's 0. I don't have to remember too many numbers.
Yeah. But
Celsius
I remember learning that as a little boy, as a little kid in elementary school. And here's an expert. Here is an expert. I assume, with a lot of scientific education. I kind of skimmed over his curriculum vitae because I remember reading it in other cases, and I just assumed this guy's a real expert. But in this case, I think it's a fail. And if you're trying to indicate that you can tell from an iPhone battery temperature that has something to do with anything at all, shouldn't you have known what the temperature was in Canton that night at that place at that time?
Right. And I don't know, maybe I'm out of line, but I think that the fact that the phone might have been in his pocket, in his jacket, and it might have caused it to be warmer than it would if it was just laying out in the snow.
I didn't get that whole thing. I know the point he was trying to make, but it just I don't know. The really important thing is whether the
I don't know.
I don't know either. So all right, we're all done with Mr. O'Keefe's phone for now, and we go over to Jennifer McCabe's phone and the notorious Haas long to die in the cold. Whiffin could not vouch for the chain of custody, nor all of the important hash values required to verify such data.
Yesterday in your direct testimony, you didn't mention anything about the hash value with regard to Jen McCabe's phone, did you?
Not in my testimony, no.
The answer is no, correct? No. However, isn't it correct that in your report of December 2024, you had an issue with the hash value from the data from that phone?
I didn't have an issue with the hash value at all, no.
So you didn't note that it was not possible with the gray key extraction as the PDF containing the extraction has its value, that it was unsigned? That was not an issue in your report?
The hash value matches, but because I didn't do the extraction, I'm unable to actually validate that was an original hash and hadn't been modified.
Okay, I'm going to stop this cut right there because, I mean, one of the major evidentiary rules that baffles all of us, but, we get it, is hearsay. What about electronic hearsay? In other words, data is coming from another phone and it's being downloaded by someone else onto a device that you're not controlling. And now this expert is on the stand talking about this extracted, downloaded data. So isn't it kind of aligned with a hearsay objection, especially where he doesn't know the chain of custody? He can't vouch that it was an accurate extraction. I have a problem with that.
Yeah, I was just thinking the same thing along the lines of hearsay, but I think it would be that the foundation is not clear. I mean, you need to have the foundation, you need to have the original, or you need to know how it was downloaded or how it was extracted. And I don't think he knows that. He just said that.
Yeah, you're right. And I think they're just assuming that because he's a scientist and he works for this Cellebrite corporation that we've all, started to worship through these true crime cases. Oh, well, stop, picking away at all these little little things. But no, I agree with you. It's a big point.
Exactly.
Yeah,
So you didn't do the extraction, but you couldn't validate the hash value, could you?
No.
So you couldn't determine whether or not any of the data on that cell phone of Jen McCabe had been tampered with, correct?
I take a holistic view of the data and try to find anomalies and didn't see any that raised any flags.
That wasn't my question, sir.
Okay.
I'll try it a different way. you concluded that the hash value was unsigned, correct?
Correct. They were always unsigned. Okay, apologies.
You concluded that the hash value was unsigned, correct?
Correct.
Thank you. And you went on, did you not, in your report to say that this hash value could be used as a suggestion of authentication, but cannot be guaranteed 100%, correct?
Correct.
Did you discuss any of that doubt, that suggestion of authentication but can't be guaranteed 100% at all in your direct testimony yesterday?
I didn't know.
And again, hash values are very important concepts for data forensic examiners, correct?
For integrity, yes.
Do you know the chain of custody of Jen McCabe's iPhone?
I don't know.
So you don't know the chain of custody of her iPhone. You have an unsigned hash value, and you can't guarantee the hash value authentication, correct?
No.
The objection's overruled.
Not from the hash value, no.
Why wasn't there a motion to exclude this, or why wasn't there a motion to immediately, kick this out? I don't get it.
I don't get it either, because the authentication, the foundation for what he's testifying about is not there. He doesn't have it.
And so it's not, it can't go in. It can't go
in. Yeah, he's examining something that he doesn't know where it came from. I mean, he doesn't have, maybe they needed to have the person who extracted the data testify about how he extracted it and blah, 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 and then have this expert come on.
I agree 100%. I mean, why weren't attorneys jumping up and down with a motion to strike this evidence and get it the hell out?
Well,
and the other,
go ahead.
No authentication. That's basic. Even a law school L2 student in evidence knows authentication is basic for anything, unless it's self-authenticating, and this certainly isn't. So there's no authentication. There's no chain of custody, and he wasn't there for the extraction. So how this went in, I don't know. But the thing that really boggles my mind, what the heck is a holistic view of data by a scientist?
Holistic, I guess. Well, what accent where is he from? Australia or I don't know.
Great Britain. I don't hold that against him. One of the local columnists, was making fun of him.
No, I'm just thinking that maybe they use a different term, a holistic, like looking at the whole. But to me, it sounds like medicine. Like he's saying a holistic view of, to me, it sounds like it's, I don't know. It doesn't sound right to me, but I'm not in technology, so I wouldn't know. But the holistic does sound a bit strange, and maybe it's a term they use where he's from, but a holistic approach, like that sounds
when I think of holistic, I think of people standing at those bins of legumes and oatmeal, and they're wearing their multicolored shirts, and they're scooping all this stuff out of it. I'm not thinking about a scientist where everything is ones and zeros and there's only one correct answer. In science, there's only one correct answer. I mean,
yeah, I'm thinking of like a doctor who uses holistic medicine to, I don't know. The word doesn't fit here, but again, I'm not a tech person, so I don't know if it's a word that I have no idea, but it does sound strange.
You know what I'm thinking of? Like over 50 years ago, scientists had the technology to get people in orbit around the Earth and then on a perfect trajectory to the moon so that they didn't spin off into the rest of space, into a perfect orbit around the moon, and then landed them on the moon and brought them back. And they didn't have the computer technology that we have now. They say that the computers on the lunar excursion model were less powerful than what we all have in our cell phones. So 50 years ago, scientists knew how to do math and knew that it was either a 1 or a 0, and that's it, or a combination of a billion of those. And what comes to mind is the women who actually plotted all of that for NASA. And John Glenn demanded that they be there when he went into orbit because he didn't trust whatever computers they have. You have to be accurate in science. That's my point of my little rant there. You have to be accurate. You can't say, well, it could be this, it could be that. Well, I don't know where this came from. Oh, there's no authenticate. It's garbage.
I don't even know. You're right. I don't even know how this even got into evidence, how his testimony got into evidence, and why it wasn't challenged.
Yeah. Hidden Figures is the name of the movie that recounts what I was talking about with the women at NASA that were the only ones that knew how to, do the math to get the people in orbit and then on the moon. But anyhow, that was when there was such a thing as science. It's ones and zeros. Now it's like, well, could be this, could be that, we don't know. But if you think that's bad, if you think that's bad, not only did Cellebrite discontinue the software that showed Haas Long to die in the cold at 2:27 last year, but Whiffin acknowledged that another company's reliable software still showed the famous search happening at, guess when? 2:27 a.m.
However, the competitor of Cellebrite that we just talked about, Magnet Forensics Axiom,
Yes.
that program at the first proceeding showed the 2:27:40 a.m. timestamp, correct?
Correct.
And as a matter of fact, as you sit here today, the Magnet Forensics program, Axiom, still shows the 2:27:04 a.m. timestamp, correct?
As far as I know, yes.
And Magnet Forensic Axiom is a reputable company, correct?
Correct.
So it goes down from there. One more cut of Mr. Whiffin, and then we'll move along. But it just stood out to me when I saw that. And I think we all know that the search on Jennifer McCabe's phone, Haas Long to die in the snow, disappeared. And Whiffin acknowledged that there's reasonable doubt over the circumstances of that disappearance.
You stated yesterday that deletion occurred after January 31 of 2022, is that correct?
Correct.
But you couldn't determine how that deletion occurred with certainty, correct?
Correct.
And you gave 3 possibilities that you analyzed, correct?
3 or 4, yes.
3 or 4. And one of them was deleted by user, correct?
Correct.
Another one was that the search occurred but never loaded.
That would be the reason that there was no data found in the history.db file.
But that was another of the 3 or 4 reasons, correct?
That wouldn't cause the deletion of the record,
Right,
necessarily.
Right. And then you you discussed those possibilities, but you can't state with certainty how that deletion occurred, can you?
Correct.
You have doubts about how it occurred, is that fair?
Yeah, I have an idea how it occurred, but I can't prove it.
I'm sorry.
Yeah, no, it's okay.
No, please finish. I want to make sure you finish.
I have an idea of how it occurred, but I've not been able to replicate it, so my idea is unsubstantiated.
So is it fair to say you have some doubts
Yes.
about how the deletion occurs?
That's fair.
And you believe your doubt is reasonable
Yes.
under the circumstances?
Yes.
When you have the prosecution's own witnesses saying reasonable doubt, even on a less major issue than this, when you have the Commonwealth's own witnesses saying there's reasonable doubt, you're in trouble, in my view.
Yeah, because it involves a search regarding how long to die in the snow. And that's a pretty much the information that somebody knew, or Jen McCabe knew, that he was out there at 2 whatever in the morning.
Isn't that consciousness of guilt? I've heard other people say that it could be construed as consciousness of guilt, that people start deleting things on their phones. I mean, remember, and we're not there yet in this trial, but the two Bryans, Albert and Higgins, disposed of their phones. Higgins going so far as to drive down to the Cape to a military base and, remove his SIM card and cut that up. Remember that?
Yeah.
I mean, so when you
And
have
hadn't he received a letter? He'd received a letter.
yeah,
right?
yes,
Not
he had
destroy
to,
it.
exactly, a preservation order. And so when you have multiple people doing funny things, getting rid of their phones and deleting things, and your own witness, the Commonwealth, thank you, is saying, well, there's reasonable doubt about this. I think, we could get into the timeline. There's a lot of trouble in the timeline, but I think just what the statements of the witnesses are doesn't spell well for the Commonwealth. So do you want to move on? Have you had enough of the expert?
Yeah,
Okay,
I'm just, it's just, if I were a juror, I would be like, I'm not taking this into consideration.
Yeah. I was really busy this week doing a lot of stuff. And so I would go home and I didn't need coffee because just watching this guy kept me up. And there's so much more. I would encourage people to go back and look at the whole thing. But I hope we've hit the highlights. Speaking of lowlights, here's Jennifer McCabe. She was on the stand for 3 days during the second week, and direct examination by the special prosecutor, Hank Brennan, right off the bat came out and made two anticipated statements or allegations that were attributed to her.
We saw them moving John towards the ambulance. And at that point, Miss Reed started yelling to Miss Roberts, "Go check on him. Are they working on him? Is he dead? Is he dead?" And at that point, myself and Miss Reed got out of the car, and she started yelling and pulling on me to Google hypothermia and Google how long it takes for somebody, to die in the cold.
At some point, were you with the defendant when she spoke to an officer and a first responder?
Yes.
Do you remember if the first responder was a man or a woman?
I remember there was a woman right next to us, yes.
Do you remember if that was before or after the defendant asked you to search about hypothermia?
I'd be guessing if I then don't.
Don't guess. Mm-hmm. When the defendant was speaking to the first responder, the woman, were you near?
Yes.
Did you hear or do you remember the defendant saying anything to the first responder?
Yes.
What did she say?
She told the first responder, "I hit him, I hit him, I hit him."
Okay, keep that in mind. We're going to come back to that. But on cross-examination by defense attorney Alan Jackson, McCabe acknowledged that she and Carrie Roberts have spoken many times before coming to testify in court, but balked at the suggestion that they were getting their stories straight.
You have discussed this case
Yes.
with Ms. Roberts,
Many times, yes.
and you've discussed the specifics of her memory, which would be reflected in her testimony, correct?
We talked about what happened that morning.
So you were talking about what she remembers happening that morning, correct?
No, what happened that morning.
Okay, so not to put too fine a point on it, Ms. McCabe, but if you ask me what I had for dinner last night, it's my memory of what I had for dinner last night. Would you agree with that?
I did.
Sustained.
Did you talk about her perception of what happened that morning during the last year?
We've talked about what has happened, yes.
Okay, so I'm trying to break it down between you and Ms. Roberts. You've discussed her perceptions and her memory of what happened, as well as, and separate and apart from, your memory and your perceptions, correct?
Correct.
So there have been circumstances in which you and Ms. Roberts have compared, by definition, what she remembers versus what you remember, correct?
I wouldn't say compare.
Now let's move to what would you say in terms of what you've discussed and why?
I would say that we've both talked about what we've discussed, but it wasn't like a comparison. We weren't comparing anything.
you've talked about what you discussed. What does that mean? Talked about your testimony?
No, we've discussed what happened to that moment.
Right.
And in those moments. So, when I got a phone call, and that's my story.
Okay, so that's your story. And, the allegation that the defense is trying to raise is that, Carrie Roberts and Jennifer McCabe have met a their times and shaped their. Do you think this is an argument the jury will buy?
I'm not sure. Because I don't know. I guess it depends on how the argument is put forth, that they discussed their stories. They discussed, because at the end she says, "That's my story."
Yeah. And the allegation, of course, is that the district attorney, Michael Morrissey, is the guy that's behind it all. And so Jennifer McCabe was asked, and she acknowledged that there was preparation with the district attorney's office at least, she said, 4 or 5 times.
How many times have you met with anybody from the DA's office? And I'm just going to limit the time frame right now in anticipation of your appearance in this trial yesterday and today.
I'd say roughly 4 or 5.
Can you give me a time frame when those 4 or 5 meetings were?
I don't have dates. I do remember at one point I met with Mr. Brennan. He was new to the case.
Okay, so, she met with her friend Carrie Roberts, and she met with the DA at least 4 or 5 times, I would guess. I don't know. You know how the background of this whole thing is that the town is very close-knit, and the McCabes and the Alberts are very close. Well, I found one little side step that Alan Jackson took really interesting, and I was surprised that it took the judge 3 minutes to shut him down. But I found it interesting anyhow that Mr. Jackson asked Jennifer McCabe about the families. By the way, we've had commenters say, is there a chart of all the interrelationships? Well, I don't know if there's a chart, but Alan Jackson got away with about a 3-minute probe into that very subject.
You're married to Matt McCabe, correct?
Yes.
Your sister is Nicole Albert.
Yes.
Nicole is married to Brian Albert.
Yes.
It was Brian Albert's home that you were at, 34 Fairview, that you arrived at, where John's body was found, correct?
Yes.
The same home where that late night gathering was on January 28th, going into the morning of the 29th, correct?
Yes.
Would you consider yourself to be close with your sister Nicole and Brian?
Yes, very close.
Your families it's not just you and Nicole, your whole families are close, correct?
Yes, we have a very close family.
How long have you known Brian Albert?
Since I was in kindergarten.
You consider him, even though he is not blood related to you, you consider him family?
Yes.
In addition to Brian and Nicole Albert, you're also very close with Chris and Julie Albert, correct?
Yes.
Just to be clear, and I'm going to do this slowly,
Okay.
Brian Albert's younger brother is Chris Albert, correct?
Yes.
Chris Albert is married to Julie Albert.
Yes.
You consider Chris and Julie family, even though there may not be a blood relation as well, correct?
Yes.
Chris Albert is a Canton Select Board member, is that right?
Now he is, yes.
And the Canton, that's in Canton? I said Select Board member. Did I mention Canton Select Board member?
It is in Canton,
Okay.
yes.
All right, obviously it's in Canton. The Canton Police Department reports to the Select Board, correct?
I'm not aware.
You're not aware of that echelon?
No.
Okay. You're aware that Brian Albert, your friend of, I'm not going to say how many years, but since kindergarten, was a Boston police officer.
Yes.
He had been a lifetime law enforcement officer for some 30 years before he retired recently, correct?
Yes.
He's a trained first responder, obviously.
Yes.
Brian Albert and Chris Albert have another brother named Kevin Albert, correct?
Yes.
Kevin Albert is a detective with a police department, correct?
Yes, I believe that's his title. I'm not
Which
100%.
which police department is Kevin Albert associated with?
Canton.
And you've grown up in Canton your whole life, you indicated.
Yes.
Your entire family has grown up in Canton, correct?
Yes.
And you, Ms. McCabe, have 3 sisters. Nicole, we've talked about. You also have a sister named Shelley, is that right?
Michelle, yes.
Michelle? Mm-hmm. And Denise, who you mentioned in your direct examination.
Yes.
Nicole is also known by nickname, is that right?
Yes.
What is Nicole's nickname within the family?
Coco.
All right, and about that point, the judge had had enough and cut the whole thing off. At that point, the judge just had pretty much had enough and said, okay, that's enough of that. But did you follow all of that? Could you do a chart now?
Yeah, I had done a chart before last year. Remember when the first time I was introduced to this case, I had to draw a chart of everybody.
Oh, I knew I had seen a chart somewhere, and I didn't know where. Well, you did a chart.
I did. I don't know what I did with it, but I did do a chart. Yeah.
I knew I had seen a chart somewhere, and I didn't know where it was because there's so many other people that have been covering this case. It boggles my mind that there are so many people that have covered this case, there's just so much information that's out there, and I've read a lot. And this is my 3rd notebook.
Wow.
This is and I've gone paperless, so most of it's on the computer. But I'll speak for myself. People of my generation tend to like stuff written down in front of us.
Yeah. Well, I do too. I may not be of your generation, but I still like paper. But it's easier sometimes to have it on the screen because you don't have to carry paper around. But you introduced me to this case, and I remember getting so confused with all the parties, and it was a question and answer session where you were educating me on the case, and I was asking you, wait, you were talking about all these people, and I'm like, wait, I have to make a chart. So then on the next show, I made a chart for myself. So
I think one of the newspapers, I can't remember, I think it was the Herald, because people attack me for it, but that's my newspaper of choice because, all through law school, riding in on the subway, we call it the T. You really can't read a broadsheet newspaper. So reading the Herald, I got in the habit of reading the Herald. I think the Herald actually had a chart. So anyhow, I guess at this point, I guess we could finish up by taking a look at, there was an incident in which the FBI showed up at Jen. The FBI.
Interesting, because I heard about that, and I heard that she wasn't allowed to say it was the FBI.
That's right. Yeah, that's right. And they weren't allowed to say there was another trial. It was a proceeding. So yeah, they're not allowed. I think the jury would have to be really stupid not to figure it out, because the way it was explained to the jury was that it was a law enforcement agency that was not the Canton police and that was not the Massachusetts State Police. So what's left? I mean, it's certainly not the Florida State Police.
It's not the Drug Enforcement Agency because it's not, or the ATF.
Yeah, but I don't think, I guess, because Brian Higgins is ATF, but the ATF generally doesn't, in my experience anyhow, correct me if I'm wrong, I don't think ATF investigates murders. So anyhow, the FBI, or a law enforcement agency that's not Canton and it's not the Massachusetts State Police, showed up at her house and they asked to interview her, and she said she wanted 10 minutes.
But she went in and called.
Yeah, exactly.
They told you that they would, at that point, they identified themselves as being law enforcement agents, correct?
When they called me, yes.
And they told you at that time that they were not with Canton Police. You knew at least they were not with Canton Police Department. They were not troopers with Massachusetts State Police, correct?
Yes.
Okay. And they told you that they would like to have an interview with you. They'd like to have a sit-down talk with you, correct?
Yes.
You told them that you would be willing to submit to an interview, but you needed about 10 minutes to get ready, correct?
Yes.
Okay, so during those 10 minutes, McCabe first told the agents from an unnamed agency that she had called her husband and Carrie Rogers, and that's it. And so there was an interview until her husband came home, at which point the interview stopped. She was not comfortable. But after the interview, She called the agents back, admitting that she had not told them the whole truth, and that she had also, in those 10 minutes, called Peggy O'Keefe, the DA's office, and also Brian Albert.
You ultimately called these officers back, correct?
Yes.
And you explained to them that you had been untruthful with them, correct?
I explained that I had forgotten to mention a couple of people that I had reached out to.
You had forgotten. Is that your testimony?
Yes.
You had forgotten. You remembered Matt and you remembered Carrie, but you had forgotten the others that you had just contacted maybe 30 minutes before.
Yes.
There were 5 people that you contacted, weren't there?
I contacted Matt.
Let's go through them. I'm just
Yeah.
asking yes or no. You know the
I
number?
know 4 off the top of my head.
Okay, let's go through them.
Okay.
You contacted your husband, correct?
Yes.
You contacted Carrie Roberts, correct?
Yes.
You contacted Peggy O'Keefe, correct?
Yes.
Then, Ms. McCabe, you contacted the district attorney's office, correct?
My witness advocate.
The district attorney's office.
My witness advocate who works
Miss-
for the district attorney's
Thank
office.
you, Ms. McCabe.
Yes.
And you also left out that you contacted Brian Albert himself, correct?
Yes, my brother-in-law.
For some reason, your brother-in-law, who's the 30-year Boston police detective, correct?
Yes.
And on whose lawn John O'Keefe was found dead or dying. Objection.
I'll allow that.
Correct?
Yes.
For some reason, you did not want these officers to know that you had communicated specifically with Brian Albert, the homeowner, just before you talked to them. Correct?
No, incorrect.
There was some reason that was important enough for you to lie about that, even though you had been admonished that it's a crime to lie about that to those officers. Correct?
Incorrect. I didn't lie to them. I had forgotten.
So it was a period of approximately, we think about a half hour had transpired between the time she made all these calls and the time she says she's forgotten. So I don't know. I think Jennifer McCabe came off better the second trial. I think she tried to be more likable. I noticed that she was looking over at the jury many times that she answered.
Yeah, she did better this time around, or she's doing better.
Yeah. One just has to wonder, the FBI comes around and wouldn't the first call, I mean, I'm an attorney, sure, but wouldn't the first call you'd make is to your attorney? The FBI, now she's not allowed to tell the jury that it's the FBI, but they'd have to be working on 2 brain cells to not figure it out.
Yeah, but I don't understand why she's not allowed to tell them that it was the FBI.
Well, in the first trial, I think if I recall correctly, that the justification for that was that the investigation was still ongoing and it was supposed to be kept hush-hush as a matter of continuing investigation. At this time, I really don't want to speak for anybody that says why it has to be so hush-hush, because it could be cut both ways. But I was going to wonder what you think about the fact that, they come knocking and instead of calling her attorney, one of the things she said, which was amusing, not funny, was in retrospect, she said that one of the reasons she had to wait 10 minutes was, I hadn't brushed my teeth, which...
Going to be completely honest, I hadn't brushed my teeth.
I don't know what difference that makes, but...
I mean, if somebody came to my door and wanted to talk to me and I hadn't brushed my teeth, I probably would say, can I take a moment to freshen up?
Well, I don't think they had cameras. I mean, I don't think so. I don't know. But in any event, why would she call? I can see why she called Carrie Roberts, because I think it's fairly clear that those two had to keep their stories straight. I mean, that's just a fact. So that's why she called Carrie Roberts. And of course, she called her husband, hubby, what the heck is going on? and the DA's office, of course. I'm shocked that the DA's office didn't say, don't say anything. But then again, law enforcement respects law enforcement. But why in heck would she call Peggy O'Keefe, John's mother? That baffles me. And I know there's theories out there, but I just don't get why she would call Peggy O'Keefe. Do you have any ideas on that?
No, I don't know why she would call the mother. I have no idea. But is it reasonable that she forgot to tell the FBI who she called, or
No.
did she think about it and say, I better tell them because they're going to find out anyway?
Yeah, and there is a fine, including a huge fine and imprisonment for lying to the FBI. You don't lie. That's why, if anybody, just a little bit of legal advice here, if the FBI calls you, call your attorney. The Fifth Amendment exists for a reason, because I'm not saying don't talk to them. I'm saying call your attorney and get some good advice. What is the issue? Who's the target? What are they wanting to know about? Can you make a statement? Are you the target? Because if you are, again, call your attorney. But in any event, it just is a little bit odd the way that whole thing was handled.
Well, she eventually came forth with who she called. So
eventually, under the threat of penalty.
Yeah.
Yeah. I mean, isn't that why Martha Stewart went away, because she lied to the FBI?
I thought it was insider trading or something.
Well, yeah, that was the initial charge. Absolutely. But I think one of the charges that put her away briefly. In any event, let's get back to this case. In this retrial, as you heard Jennifer McCabe claiming that Karen Reed, and we're going to get back to the old where we started out here, that Jennifer McCabe claims that Karen Reed said, I hit him 3 times. But she fought back with Alan Jackson when he suggested that, you know what? That was never in her testimony in her previous statements, especially when she was speaking to the grand jury.
Not one time, Ms. McCabe, did you utter the phrase, I hit him, as it relates to my client in front of that grand jury on April 26, 2022. Did you? Not once.
I'd have to read through the 227 pages to see.
As you sit here today, do you remember ever saying to those grand jurors, she said, I hit him, I hit him, I hit him, in front of a female EMT?
I've spoken to in a few grand juries. What I said specifically at different ones, I don't recall at this moment.
Okay, so the issue here really is that she refused to admit that she had never testified to the grand jury that Karen had said, I hit him 3 times, saying she would have to read the whole 227-page transcript, something that Judge Cannone was having none of. But, Jackson went through a number of specific pages of the transcript meticulously, and with her fighting him all the way, saying, well, I don't know if that's what the transcript says, or that doesn't refresh my memory. So I wrote down 7 or 8 different page and line references to the grand jury testimony where Alan Jackson pointed out that Jennifer McCabe did say things like, Jennifer McCabe did say that Karen Reed had said such things as, could I have hit him? What if I hit him? Did I hit him? But nowhere in that grand jury testimony did McCabe ever say that Karen Reed said, I hit him. And also the statement from McCabe that Karen Reed said, I hit him, was not in any police report from Officer Lang, from Trooper Proctor, or from anyone else. That does not appear in any police report. But apparently she remembers better now. So that's enough of the video cuts. There are 2 other big things happened this week. 2 other really big things happened. And the U.S. Supreme Court did not grant certiorari. So her appeal to the U.S. Supreme Court on the basis of the fact that they're claiming that 2 of the counts, the jurors were unanimous in finding her not guilty, although it was not read as a verdict in the court. And this went all the way up to the Supreme Court, and they had a pile of cases that day, and this was not accepted by them. So how would it be to have a job where you don't have to take all the questions that come to you?
Yeah, you get to decide which ones are worthy and which ones are not.
Yeah, so they didn't, and most of us thought that was going to happen. Even Attorney Mark Betterow, who we've had on a couple of times, he is an advocate, an unabashed advocate for the Karen Reed team, and he doubted that it was going to be taken up, even though, it was a good faith question. But so that chapter is done. And the other big thing that happened this week is that Judge Cannone ruled that ARCCA will be allowed to testify, the major experts for the defense. She agreed with Special Prosecutor Hank Brennan regarding the alleged lack of candor on discovery. I said alleged because I never bought the whole thing, and I thought that Robert Alessi had done a really good job spelling it all out, day by day, communication by communication. But Judge Cannone said that she agreed with Brennan, but she said the defendant's right to a fair trial is more important. But she again showed her bias.
Well,
And
that's
she
what I
said,
was going to say. Yeah.
she said, go ahead.
That's what I was going to say. She went and reprimanding him, reprimanding the defense, and then said, you're going to get this. You're going to get this, meaning you're going to win, but I have to say my words first. In other words, why?
She cut him off. She allowed Brennan, I believe she said, I'll give you 10 minutes, and he took that. And then Robert Alessi got up and she cut him off. She wouldn't even let him talk beyond like one sentence. She said, you're going to get this. But so I thought that was extremely rude, and it didn't show judicial temperament.
No, it didn't.
And I have to be restrained in what I say because I am a licensed attorney in Massachusetts, but I did say it. And the other thing that I thought was intemperate was she expects rigorous cross-examination from the special prosecutor. Well,
that's always expected for any witness.
Yeah, aren't you? If your opposing counsel has a witness that croaks your case, don't you have a legal duty to do rigorous cross-examination? Isn't that the name of the game? So for her to say, I expect rigorous cross-examination, that's kind of like a previous order that came from the court after the voir dire of Dr. Russell, I believe it was, that said, well, here are some points you should bring up in cross-examination. I mean, she's obviously, pushing Brennan forward, and I don't know.
I mean, judges are humans too, and I guess they get frustrated or they get upset as well, but it's about the temperament and about not letting that show. And I don't know, sometimes it leaks, I guess, but
yeah, I don't know, it shouldn't show to the extent that it does. I mean, I don't know. Do you have time to stick around and take a look at a couple of our viewer comments? Yeah. Okay. So user nothing12345 says, I don't think that Hank is doing this of his own free will. It felt forced, deliberate, and desperate. Not a good style. Is he backed into a corner trying to fight his way out or something else? I don't know. Well, he was retained to do a job when none of the other prosecutors in the district attorney's office would do it. None of the other top prosecutors in the Norfolk County district attorneys wanted to try this case. And so he was named special prosecutor, and so far to date, he's made about $250,000 doing it. And, he's got to do a good job.
Yeah, I don't think, I think he would, he's doing it of his free will. I mean, maybe there's pressure, but I don't know. That's now making me think, could he really be forced to do this? Like, is somebody forcing him? But I never thought of that before this comment.
I spoke to someone who knows Hank. I've met Hank, talked to him before this, not since this. And I talked to a mutual acquaintance, I'll say. He said he thinks Hank took it because it's there. And he wanted to, quote unquote, have a good time with it. That's what someone told me. Whether that's true or not, I don't know. Objection, hearsay. Here's one for you.
From Vanessa RM1G. Says, I'm gutted attorney Mark Betterow didn't get on the team, but at least we get to see him on YouTube.
There
Yeah.
you go.
Well, that was a whole deal with Turtle Boy that there was likely, she thought that it would be a conflict, which I don't.
Yeah, I didn't. If there's a conflict, I believed that it was a waivable conflict, and Mr. Betterow, went to a great extent to do everything that you need to do. You notify everybody, you get their consent, and
Permission,
you go
yeah.
forward. But she just didn't want it to happen. Our next viewer comment is Tano fine print. Ain't no fine print. Tano fine print. I don't know. Anyhow. Why are we even talking about BS statements and taillight unless we can prove a vehicle actually hit him? They need a guy from Lexus to tell the court how a human could not break the taillight. Interviews were not under oath, and I hit him, shows her state of confusion. Not one picture of the vehicle prior to being taken. Even my car service takes pictures prior to any work being done. And that's a good point. It's hard to believe that this high impact, it's not even plastic, this high impact clear material that they make the headlights out of, the tail lights out of, I should say, it would break from a human body. It's unbelievable to me. I don't know. I don't know. It's just.
Yeah, they need to prove that. And that's what I always say, that, stick to proving the case. The peripheral stuff is just gravy, but you first got to prove beyond a reasonable doubt that she backed into him and left him there, and somehow the taillight broke.
It made no sense. It really made no sense.
Okay, this is Catastrophe Girl.
I think I dated her.
This is during the first trial. I suspected she was innocent, but hadn't heard all the evidence, obviously. It was a Commonwealth's evidence and witnesses that made me think she was innocent in that trial. Someone on a message board forum said to me, wait until you hear her voicemails. Then you'll know she's guilty for sure. So I did wait for them, and the voicemails made me think she was more innocent. No guilty person would leave those furious, anxious voicemails. She was so angry and upset that she had zero idea where he was at all.
I hadn't thought of that. That's a good point, I guess. I mean, if you just.
But wasn't she inebriated as well? I mean, that could have, I mean, not that it just makes that she's upset that she doesn't know where he is, and she's inebriated, so she's overreacting, maybe.
Yeah, they'd already had some tension. All of those texts that occurred the previous day, going back and forth, they already had some tension. I guess they got back together. They were lovey-dovey, as described by one of the guys that was in the bar that night. But, you have a few, and, the emotions come out. Although number two here has a good point. Catastrophe Girl has a good point. I mean, if you had just committed I hate saying that, but, would you want to call attention to it by leaving nasty texts? I mean, good point. And our final comment this week is from Sharm Giyar. Sherry Magular. One thing they didn't do in the first trial, nor this one, well, it's not over yet, is make a chart of the families and Proctor, et cetera, and show how they are related and intertwined. If all of these names and faces are unknown to you, it is hard to keep up with. I think it made more sense to me when I saw someone's chart they had made, and that was during the first trial. People love visuals. I'm going to dig out that chart. I know I have it somewhere at home. I have it somewhere.
I have a chart too that I made, and I think on one of your shows I showed it, or I had it.
Did you?
Yeah, I did.
Oh, wow. Dig it up.
I'll see if I can find it, because I know I had to type it on my computer. But yeah, I had a whole chart because we had that question and answer session where I was learning about the case. Yeah. And I was lost. I'm like, okay, wait, who? Yeah. Okay, and who is this?
Wait. You mean you weren't taking notes when we played that cut of Jennifer McCabe a few minutes ago, talking about who's who and what? It is confusing. It's very confusing. But right, I may bring that up in the next episode. Our final feature is that we have now received comments from people in 56 different countries around the world. And a few episodes ago, I was bemoaning the fact that we were stuck at 52 and we hadn't gotten any new countries. But as of this point, we've actually had comments from 56 countries.
Wow.
And I was kicking around the idea. People said, well, you should keep track of states too. So I don't know. That might be too much. But just in this last week, we got comments from Indiana and Florida. And I know Massachusetts and New Hampshire are out there, and California. So maybe we should. If you want us to start keeping track of states that are watching us, let us know, but let us know what state you're from. So that's pretty much it. So I always ask Lainey and put her on the spot. Do you have any closing thoughts for us?
This trial is going to be long and tedious, this Karen Reed trial.
Yeah, they're saying it's going to be 6 to 8 weeks. So that leaves another 4 to 6 weeks in front of us. And, it is tedious. It is tedious to watch. But I hate it when people say this, but it is what it is. All right. Thank you very much for joining us, Yoli. I loved the most recent thing that you did. You did an episode on jurors going and visiting the scene of the crime, or in this case, it would be the scene of the alleged incident. And I found that interesting because the Koberger people won't be able to do that.
Yep.
So I'll put a link down in the detail section to that episode and encourage people to go watch your material because I love it.
Good. Thank you.
Okay. Thanks a lot.
Right.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comment section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.
I hadn't brushed my teeth.